Manila Prince Hotel vs. Government Service Insurance System, GR number 122156, February 3, 1997. Bellisillo, J. Note. Section 10. The Congress shall, upon recommendation of the Economic and Planning Agency, when the national interest dictates, reserve to citizens of the Philippines or to corporations or associations at least 60% of whose capital is owned by such citizens, or such higher percentage as Congress may prescribe, certain areas of investments. The Congress shall enact measures that will encourage the formation and operation of enterprises whose capital is wholly owned by Filipinos. In the grant of rights, privileges, and concessions covering the national economy and patrimony, the state shall give preference to qualified Filipinos. The state shall regulate and exercise authority over foreign investments within its national jurisdiction and in accordance with its national goals and priorities. Facts. Respondent, GSIS, decided to sell 30% to 51% of the issued and outstanding shares of Respondent Manila Hotel Corporation through public bidding as part of the Philippine government's privatization initiative under Proclamation No. 50. According to its terms, the winning bidder is to provide management expertise and/or an international marketing/reservation system, and financial support to strengthen the profitability and performance of the Manila Hotel. Only two bidders participated. A. Petitioner Manila Prince Hotel Corporation, a Filipino corporation, which offered to buy 51% of the corporation or 15.3 M shares at P41.58 per share, and B. Renong Berhad, a Malaysian firm, which bid for the same number of shares at P44.00 per share, or P2.42 more than the bid of petitioner. In a letter to respondent, petitioner matched Renong Berhad's bid price of P44.00 per share, pending the designation of Renong Berhad as the winning bidder partner and the execution of the relevant contracts. In a subsequent letter, petitioner sent a manager's check for P33.000.000.00 as bid security to match the bid of Renong Berhad, which respondent refused to accept. Because of this refusal by the respondent, petitioner came to the Supreme Court on prohibition and mandamus. The SC issued a TRO enjoining respondents from consummating and perfecting the said sale. The petitioner hinged his arguments on Sector 10, Second Par, Art. 12 of the 1987 Constitution. It argued that a Manila Hotel had become part of the national patrimony, having become a historical monument for the Filipino nation, and b. because respondent GSIS, a GOCC, owns 51% of the corporation's shares, the hotel business of GSIS, which is part of the tourism industry, is unquestionably a part of the national economy. Hence, the petitioner claimed that the corporation is clearly covered by the term national economy under the contemplation of Sector 10, Second Par, Art. 12, 1987 Constitution. The respondent, on the other hand, raised the following arguments. A. Sector 10, Second Par, Art. 12 of the 1987 Constitution is merely a statement of principle and policy since it is not a self-executing provision and requires implementing legislation. B. While the hotel is indeed historic, Manila Hotel does not fall under the term national patrimony. C. But even if it is, the constitutional provision invoked is still inapplicable since what is being sold is only 51% of the outstanding shares of the corporation, not the hotel building nor the land upon which the building stands. D. The privilege of submitting a matching bid has not yet arisen since it only takes place if for any reason, the highest bidder cannot be awarded the block of shares. Issue. Whether the provisions of the Constitution, particularly Article 12 Section 10, are self-executing. Ruling. The Supreme Court ruled in the affirmative. Under the doctrine of constitutional supremacy, if a law or contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch or entered by private persons for private purposes, is null and void and without any force and effect. Thus, since the Constitution is the fundamental and supreme law of the nation, it is deemed written in every statute and contract. While the Article 12, Sector 10, 2, may be couched in such a way as not to make it appear that it is non-self-executing, the legislature is not precluded from enacting other further laws to enforce the constitutional provision so long as it is consistent with the Constitution. The SC remarked that Article 12, Sector 10, 2, is a mandatory, positive command which is complete in itself and which needs no further guidelines or implementing laws or rules for its enforcement. The SC added further that there is a presumption that all provisions of the Constitution are self-executing and minor details may be left to the legislature without impairing the self-executing nature of constitutional provisions. A provision which lays down a general principle, such as those found in Article 2 of the 1987 Constitution, is usually not self-executing. However, a provision which is complete and becomes operative without the aid of supplementary or enabling legislation, or that which supplies sufficient rule, by means of which the right it grants may be enjoyed or protected, is self-executing. Hence, unless it is expressly provided that a legislative act is necessary to enforce a constitutional mandate, the presumption now is that all provisions of the Constitution are self-executing. If the constitutional provisions are treated as requiring legislation instead of self-executing, the legislature would have the power to ignore and practically nullify the mandate of the fundamental law.